so long as they don't speak. Yeah, I am ready.
Okay, thank you. Good morning. This is the April 18th, 2024 meeting of the Southern Region Board of Review. This hearing is being held via WebEx video conference at the Perry B. Duryea Jr. State Office Building, 250 Veterans Memorial Highway, Conference Room 4A9A, Hauppauge, New York, 11788. The time is now 9:18 and this hearing is officially open. The members of the board are Andrew Hames, Eric Schaub, Palin Nee, Richard Bavone, and myself, Robert Peterson, Chairman. From the Department of State is Mr. Courtney Nation and
I
Mr.
apologize.
Am I reading too fast?
Is there an issue, Michelle?
Yes, I am having an issue. I don't know if everybody else is hearing it. There's an echo. I don't know if everybody else is hearing it.
Okay, I don't
Everybody
hear.
mute your mics, please. Don't. I guess it's the cell phone number. It's not muted.
You don't think it's yourself, right, Michelle? Because you are on the phone and on your computer?
No, it's not. My phone is muted, so if someone is on the 516 number,
Oh,
if they could press *6, they'll get muted.
I'll try to mute them on my end. Yeah.
They're muted now. Is there still an echo, Michelle?
Yeah, I actually hear it now that I didn't hear it before, but I just muted that phone number.
Oh, Mr. Bisakis, can you log out Todd maybe?
Oh, right,
Yeah,
that was it.
yeah, we're gonna log out Todd. Okay.
I can't hear it.
You can,
You gotta take that off. You can't have that on. You have to get the speaker going on there. Because I can't.
Ready to go on the record. Let's go.
Okay, thank you. Good morning. This is the April 18th, 2024 meeting of the Southern Region Board of Review. This hearing is being held via WebEx video conference at the Perry B. Duryea Jr. State Office Building, 250 Veterans Memorial Highway, Conference Room 4A9A, Hauppauge, New York, 11788. The time is now 9:27 and this hearing is officially open. The members of the board are Andrew Hames, Erica Schaub, Palin Nee, Richard Bavone, and myself, Robert Peterson, Chairman. From the Department of State is Mr. Courtney Nation and Mr. CJ Ajoku. We will now hear the scheduled petitions. When you speak, please address the board and give your name, title, and legal address so that our court reporter can have all the information requested. We may have to stop from time to consult with our technical staff. In making comments to the board, please provide a descriptive narrative on matters referring to your exhibits to enable the court reporter to enter these into the record. The first hearing is in the matter of petition number 2023-0480. Petitioner is Michael Morbillo, architect for Joseph Zangrillo. The petition pertains to an existing two-story, 3,197 square foot building with mixed occupancy groups A2 and R and construction type 5B wood frame, located at 217 Main Street, Incorporated Village of Port Jefferson, County of Suffolk, State of New York. Petitioner is seeking relief from 19 NYCRR Part 1221, the 2020 Building Code of New York State, Section 1004.5, titled Areas Without Fixed Seating, which states the number of occupants shall be computed at the rate of one occupant per unit of area as prescribed in Table 1004.5. For areas without fixed seating, the occupant load shall be not less than that number determined by dividing the floor area under consideration by the occupant load factor assigned to the function of the space as set forth in Table 1004.5. Where an intended function is not listed in Table 1004.5, the building official shall establish a function based on a listed function that most nearly resembles the intended function. The petitioner wishes to have an occupant load greater than allowed by Table 1004.5. And 19 NYCRR Part 1221, the 2020 Building Code of New York State, Section 1007.1.1, which states where two exits, exit access doorways, exit access stairways or ramps, or any combination thereof, are required from any portion of the exit access, they shall be placed at a distance apart equal to not less than 1/2 the length of the maximum overall diagonal dimension of the building or area to be served, measured in a straight line between them. Petitioner wishes to have exits located at the front of the building, spaced closer than allowed by section 1007.1.1. Okay, Michael, you have the floor.
Thank you. For the record, my name is Michael Morvillo. I am the architect for the applicant. My firm is Nspire Design Group. My office is located at 4964 Express Drive South, Suite 1, Ronkonkoma, New York, 11779. So I'm going to go through just a little brief narrative of the history of where we've arrived today on this to describe how the restaurant was originally established. I did, and this is outlined in Exhibit A summary that was part of the application, which I'm going to briefly touch on. Essentially, we are talking about, it's a mixed-use building, as was mentioned. There's a restaurant on the first floor of this building, which compromises about 1,883 square feet. That includes dining room, kitchen areas, and storage areas. The establishment was originally opened up around the year 2000 as a takeout restaurant. And I had actually worked on that project back in 2000. Subsequently, as the business started to expand, they expanded into another part of this, the first floor of this building. The building had been previously divided with a small lemon ice shop and then the takeout restaurant. The lemon ice shop was taken over for a dining room, and in 2003, a sit-down restaurant was proposed, and a floor plan was submitted to the village back in 2003, which illustrated 69 seats. That is noted as Exhibit B2 in the application package. In 2005, there was a certificate of occupancy issued for the restaurant, and it was understood that that was for the entire restaurant, but upon closer reading of the certificate of compliance, which is Exhibit B3, it was actually for an interim renovation to add a handicap bathroom inside of the restaurant. So what we have is we have an Exhibit B1, which shows the restaurant that had existed as a takeout restaurant, a little bit of a dining area, and then an added handicap bathroom. And that had been approved back, early on, around 2000 actually. And, but around 2003, Exhibit B2, a plan was submitted to the village, which shows a seating layout, which has basically existed for the past 20 years. And it shows a dining room with approximately 69 seats. And that business is operated that way up until close to 2018, when the building and restaurant owner, who were one and the same, were notified that there was not a CO for this space. I believe the applicant was going through some sort of financing on the building, needed to produce the CO. Upon further scrutiny of the CO, it was clear that, it was determined by village officials that this was not a certificate of occupancy for the restaurant itself. It just, the timing of it was, it was related to an application for the bathroom that was issued in 2000, the year 2000. The floor plans for The expanded 69-seat restaurant was submitted in 2003. They received the CO in 2005 and basically mistook it for the CO for this expanded seating area. Upon finding out in 2018 that they needed to update their CO, the first step for that was to go through a planning process in the village, where they basically had to get approval from a planning standpoint for customary things, parking, use, and other things. That was ultimately, they were ultimately approved by their planning board, with the caveat that any seating in the restaurant be approved by the building code official in the village. And that planning board approval is documented as Exhibit C from March 12th, 2020. In subsequent to that, 2020, we know what happened. This was March 12th, was this hearing and decision. COVID came and a lot of things were put on the back burner, and they were delayed with that. So there was roughly a year or so delay due to COVID. And there had been some discussion back and forth about the seating levels. The fire marshal has always posted a minimum 50-seat occupancy, because my understanding is that they recognize the front exits of the building. There has been a rear access or exit in the building also, which has an exit sign over it. And for whatever reasons, on their periodic inspections, they recognize the space as 50 because they saw it as one exit of sorts out the front of the building to Main Street. And they've always had this 50-seat minimum in the space. The owner never really contested it, because for years after fire inspections, there was never any comments made about the seating levels, although there at a later time in my later discussions with the fire marshal, at least most recently in the last couple of years, there has been concerns about seating layout change. So that was something that was a concern for, at least that was expressed to me about the restaurant, was that the seating layout may not have always been in full conformance with what was on the 2003 plan. So that seemed to be an issue. The client basically was working to legalize these, I'll say these 60 some odd seats, 68, 69 seats. And there'd be kind of what I would call a sort of a chicken and egg scenario, which is the client had been using this level of seating for years. We were going into the fire marshal and to the building department to make an application. And they were saying, listen, you have to remove you have to be down at your 50 seats in order for us to entertain this application, and you need to remove seats. We basically got up to a point where in order for this application to ultimately come before your board, my client has removed those seats and has been operating at a substantial loss in his restaurant for the last year or so, because he's at 50 seats. And he's always had, his business model has been on these 60 some odd seats. So we're before you, this board, because we started entering into discussions with the fire marshal as far as how we could have more seats in the space. So generally, in other applications, and certainly in this one, we were looking at section 1004.5.1, which is for increased occupancy. Fire marshals were taking the square footage of the space, dividing it by 15, which is off the standard table. They came up with a number which is around 40 seats for this space. And certainly we wanted to always go according to what was submitted, which was originally, mandatory aisle widths, mandatory depth of tables, back-to-back seating, clearances and other things. And pretty much the same plan that was submitted 20 years ago, we updated it to clarify. And that is, let's see what that exhibit that is. We have it on a floor plan. I'm gonna just double check my exhibit on this. It's basically the most recent floor plan that came in with the application, which is dated, August 5th, 2023. And, it's a plan that, indicates, two dining rooms or two dining areas, with, two aisle seats. Two aisles, serving seating on, both sides of the dining room. We're basically looking to achieve that. The fire marshals, our conversation with them was, they were concerned that the tables were going to be moved because they had observed that on party circumstances, where they would have some larger groups of people, sometimes the tables would be pushed into the middle of the room, or they would reserve the room for a bigger group and not, one dining room might be used for groups, so they might take 3 or 4 tables and put them together in the middle of the room. And they may have other things to share on that. But basically that the applicant wasn't working in full compliance with that approved seating chart. They, in some emails and in conversations, it was expressed to me, and I interpreted that they did not want to be in a position to have to enforce the building code on routine inspections. Their method for how they wouldn't have to basically execute the code was that the table should be bolted down to the floor. So currently what he has is freestanding tables. If they wanted to have increased seating level, they would need to be connected to the floor because as fixed seating, which would then give them the ability to have that increased level. The client's model of business has been basically the chairs and tables are moved every day. They clean up the floor, they mop the floor, they move things around. They're not booths. So, and then they do like once a week or once every other week, they have a deep cleaning. Somebody comes in, steams the floors, does the work to sanitize the floor in the restaurant. It wasn't deemed feasible by the client. My recollections of my discussions with the fire marshal is that they weren't comfortable approving an increased seating level, without that being done. So we had conversations with at that time, the counsel or head of the building department, I forget his position, but he's Attorney Richard Harris. And the sense was that if you take this to a state level and let them evaluate it, we would be more comfortable with that because we don't want this to be put on us. We don't want to be this constant enforcement or something else. And they said file for a variance and come before this board. And so that's where we are today. What I'll say is that something that was always been a part of this restaurant is there's always been this rear entrance to the restaurant, which historically has been there. From what I've heard from previous fire marshals that were there, that worked for the village, they've always recognized that. There has been an exit sign on it. There's been this rear exit that leads out to a back municipal parking area, village parking. And so that was something that kind of came away from our initial conversations because the fire marshals have contended that this access goes through a kitchen and therefore we know that you can't exit through a kitchen. However, our contention was that this is really more of a waitress area. It happens to be adjacent to an area where they do some dishwashing. There's a dishwashing station adjacent to this area, but not an area that you're passing through. And then the building actually has a little bit of a split level in the back where you go up several steps to the kitchen area. So, we had said, listen, we've had these sort of vestibule type areas. I'll say quasi waitress station areas, the waitress may put some things down, get a soda, but it's not where there's an employee or you're going some sort of circuitous route through a kitchen. There's a direct access to an exit. We always felt that should be considered as potentially a mitigating point for any seating in the restaurant, or also it shouldn't be abandoned potentially. When we had put in the application to the state, that we had gotten some initial feedback that we should, there should be something that prohibits people from going into these other adjacent areas, if that's to be recognized as an access. So we have a revision number 7 on the drawings that were submitted, which was, again, the revisions dated August 5th, 2023. And where we're saying we have a dedicated marked path as per New York State Building Code or Building Code of New York State 1016.2.5 commentary. Basically that this is a non-working portion of the kitchen as per 106.2.5. Generally, this is an area that there's not people standing there regularly, where you're gonna have to go through a working area that's congested. It's basically an area that's always open, occasionally off to the side. The waitress will fill up some soda cups and this or that, and maybe do a little bit of prep before they bring some meals.
No
out.
cooking equipment in there,
No
no
cooking equipment in there.
grease-laden vapors or any
Correct.
gas? Okay.
Correct, none of that. There's actually a little bit of storage, a little soda station, and then a little dump sink for like spent soda or glasses or things like that. But this has been used, so we said that we did have an exhibit D, which has pictures of the restaurant. And in essence, what we would be doing is putting some sort of gate or a control at the bottom of the stairs so that people do not, this is not an exit sign type of thing. Same thing with the dishwashing area, which is, I think is pretty clear, is really off to the side and not in this path of travel. This is, so that's what I'm discussing this rear exit is that if we look at this, at the layout of the dining rooms and the restaurants, we have 2 dining areas, 2 dining rooms. Each one has an exit leading directly out to the street. I did a little bit of a, diagonal of the dining room, analysis, which, is more in conformance with, I think, the poll meeting, 1007.1.1, that sort of diagonal, distance between entrances and, measured between, 2 entrances. I know that there's always been discussion as far as where that dimension is taken. Is it from the center line of the doors? Is it from the inner edge of the doors? We've illustrated 20 feet, 20.2 feet. Because I've been to code classes and they've said it could be at any point on the door. So as an architect, I'm putting the furthest point on the front of that plan saying 20.2 feet from the edge of the door is less than the half of the diagonal distance of those areas of at least the larger dining room, which is 38 feet 6 inches on a diagonal. In essence, what I think we're talking about is, are these 2 exits sufficient for increased seating? We're talking about, minimum number of exits. And then also as a mitigation point, my client doesn't like taking away that rear exit. He's always had an exit sign leading out to that back area. And, he's kind of asked to abandon it. I think the client was okay with abandoning that rear exit if he's able to maintain those 2 exits and certainly maintain a certain seating level in those dining rooms. But, we're presenting this before you today to say that there's methods of meeting safe egress here for increased number of occupants. We have a compliant table layout, aisle width between tables and chairs. This has been a restaurant that has been been occupied for close to 20 years, as far as I know, without incident, as far as for egress or anything else. The fire marshals may have some opinions on other things, but we feel that, you know, bolting down tables is probably not a good business. There's a lot of businesses like this in the village, a lot of restaurants in older buildings, and generally, it's not something for this type of business I like to entertain. We did almost come to a number with the fire marshals. Again, the number was somewhere around 60 because we wanted, you know, we don't want to be at 40 seats, which is the number that they were saying. They're letting them stay with 50 because of the way that the front entrance is right now that we do have. We're less than, they have it at 50, 49 or less, obviously we're in that realm. But, you know, that's not a sustainable number for his restaurant, and we just need to kind of get to that number. They were talking about 60. Then they said if you don't bolt them down 40, we're kind of at 49, 50 right now. We have a layout here that shows how they can basically get 65 seats with a compliant layout. The client, as far as I know, has been keeping this layout. I've known him for 20 years, and he's had a successful business operating here. He wants to keep it viable. His business has suffered because of that. It's a separate issue, obviously, but he'd like to have the matter resolved, and we'd like to enter into discussion with this board and answer any questions that you may have. But in brief, that's the case before you today. So I'd be happy to answer any questions at this time.
Well, thank you, Michael. I'm not sure I'm 100% clear on the path to get to this point.
Yeah.
So if I could just, I'll spitfire some
Sure,
questions and we'll
absolutely.
open up a
Yeah.
dialogue.
Yeah.
What is the current approved occupancy for the space? For the
According to the
restaurant.
fire marshal, it's 50.
It's 50.
50.
Does the village require public assembly licenses for 50 or more? Do they do
Yeah,
annual inspections?
Yeah, they do.
Okay,
As far as I know, they do, because he just had to renew a permit for his restaurant, so, and I believe it's on an annual basis.
all right. So 50 or more, Courtney, it's 2 exits, right?
Yes.
So they would need to be at 49. And then if they were at 49, they wouldn't need a PA license. They can do 1 exit.
Yeah.
And you're looking to achieve 65.
65.
So you want an increased occupancy.
Yeah.
With not in code compliant exiting.
Well, we're contesting that the rear exit is a code compliant.
Okay, so we could talk about that
So
too.
we could talk about that.
So if we go back to look like a takeout pizzeria.
Yeah.
Had like a long counter on one side.
Yeah.
What was the occupancy back then?
I believe we're like, you know, we're under probably 16, like that's a common sort of.
Because it looks like they had stools at the front,
Yeah, yeah.
but there was no number.
Yeah, there were I would say that at that point, there were probably like 20 some odd seats. That was back early in 2000, if I do.
Okay. And then there was a renovation to move the kitchen functions to the back,
Correct.
no longer a takeout restaurant.
Yeah.
And what was that? And was that done with a permit legally?
Well, they applied, and they submitted a plan, which was exhibit, B2. And, the building inspector at that time had some comments. And, there was, as far as I know, a permit applied for it. My name is on those drawings. The records are a little sketchy at the village because it's not as clear, because things change over the years. But in brief, there's no CO that's tied to that permit. So there was application made, and there were a commented plan by the code enforcement official at that time.
What year was that?
Yeah,
What year was that?
that was 2003.
So there was levels of alterations back then, right? Courtney?
Oh, yeah, yeah.
Level
yeah,
1, 2, and 3.
yeah.
So we don't know what it was.
There wasn't a CO issue, but there was a permit applied for and
There was a permit applied for which showed the rear exit, that second exit.
and that permit was approved.
We don't know. I apologize. It's 20 years. The plan was reviewed, the records at the village, not as clear. I'm not sure if it was approved or it wasn't. However, the plan was approved or the plan was reviewed in 2003. It received, there was follow-up inspections by village and fire marshals and building inspectors for this completed plan that was constructed around 2003, and they received a CO in 2005. So the tenant thought, and the owner thought it was for this work, didn't read it close enough, never really studied it because the work was done and fire marshals and building inspectors come in all the time and they thought they had a CO. So the cases, none could be located and it appears probably none was ever issued.
So from the early 2000s, was a PA been issued by the village at all?
I'm not sure. They'd have to address that.
That's my
They'd have to
point.
address
I'm trying
that.
to get the path.
Yeah.
There's a
Yeah.
breakdown.
Yeah.
And then,
I think there was one, I thought early on, and they may have even been, they can advise on that. I thought that, one had been issued early on and it just hadn't been renewed or something along those lines.
Is there an addressable fire alarm system in the building?
No, it's not. It's
Is there any, fire alarm?
smoke detectors, other things, yes, yeah.
And what about the kitchen? Is there an AES system in the kitchen?
There is, yes, there is.
There's this is the fire marshal. So you know, they do have a smoke detectors in the building, but it's not tied to a fire alarm system.
Okay, thank you.
All right, so the reason to try and understand the journey this thing has taken, and then, if there was any oversight or anything like that, as far as the life safety is concerned, that's a great question. The apartments have always been there, so is that a non-conforming situation?
They've always been there.
Okay.
Yeah, always been there. In fact, when we had renovated the building, initially even for the takeout, we had to go, make sure we had proper fire separations between the floors. And all that needed to be improved at the time back in 2000.
Mm-hmm.
So that work was done. Like I said, the plan submitted in 2003 showed that rear exit. So that's where the numbers have been maintained.
Okay.
So we started going down a path, just to restate, where those two exits in the front were quote unquote two exits. Because of the separation and depth of dining room, and meeting that requirement in the code. So we looked at that as two. It's borderline, I'll be
So-
very frank.
So in my head, as a code guy myself,
Yeah.
If at one point this thing qualified as a level 3, because the work area was 50% or more, you would need a sprinkler system.
Yeah.
And if you put a sprinkler system in, you don't have an exiting problem.
Yes, yeah.
So is that something that was explored at any point in
I
time?
think it was discussed,
Is there a price or a number that was vetted or?
yeah, probably discussion was that, you're talking something that's between $80,000 to $100,000.
Mhm.
I've also been involved in other projects in Main Street, in Port Jeff. The firm I was with, I worked there 10 years down in the village of Port Jeff. Not great water supply for some of these fire sprinkler systems to get in there. It's just a matter of being older. I'm not aware things have changed, but there have been some buildings that have run in fire sprinklers. There was a restaurant, I believe, across the street from this. It was some sort of Chinese restaurant, and they wound up bringing in, and I understand very difficult to make that happen. But it has been looked at and just deemed like,
Cost prohibitive?
Cost prohibitive, exactly.
Does there be any look at actually upgrading the existing smoke detectors to an addressable system? for the whole building?
I think so, yeah, absolutely. I think that's definitely on the table for this,
Okay.
to make that happen as far as.
That would be for the whole building?
Yeah,
The out-of-pocket
for the
fees.
apartments, yeah.
I mean, I could see a situation where there's possibly a limited sprinkler system in the kitchen area. Because if you're going to so-called exit through the kitchen,
Yeah.
or find a way to separate it somehow where
Mhm.
that I like that option out the back.
Mhm,
If you take that away, I think the building is completely much less safe.
mhm.
Can I add? Can I
Yes,
add to your question? This is the fire marshal again. Um, the back entrance, the reason why I would not use the back entrance is because almost 100% of the time when I've gone to this building, he has stuff stored in the hallway and also like child seats that he uses for around the tables. He stacks them and he's in that hallway. So that hallway is very where it's just maybe at 36 inches wide is now much less, probably about 18 to 20 inches wide. It's usually always um, blocked or has stuff there, and I've warned him numerous times about that uh, stuff being there and that it can't be there. Just like the front north door, that the second door that they were talking about, he had numerous times after discussions with Mr. Morello about the renovations or the seating arrangements at this facility. He had a chair or a table and chairs less than 3 feet from the door, and then a sandwich board placed outside in front of the exit door. So it couldn't be used as an exit. It was always blocked. The egress was always blocked. And this was something that we took, I don't know, I probably have a good 60 or 70 pictures of days in a row after we talked to him about it. You can't have this stuff here. If you want us to agree with it, you gotta try to like meet us some way and try to make it safer so that we know that you're going to comply to and not block the egress. And he refuses to do that. It gets to the point now when he sees us walking down the block, he runs inside and he moves the board and he moves the table to get into conformance. And that's not a safe part in my part. That's why I will not, I would refuse to sign and give him more or over the 50 occupancy. And the occupancy is 50, it's not for 50 seats, it's 50 total for the whole restaurant. So I told him whatever his staff is, that you have to take out from the seating that's in the building. That's how we came up with 40 building.
Right.
And I just want to
Which is
verify
fine.
the fire marshal's statement as the building inspector. I made multiple observations of these conditions as well.
Can we ask when was the last time? I'm sorry, when was the last time you had that observation?
I could tell you that my boss had told me after we sent him probably about 50 pictures worth of like 50 different days to stop taking pictures. I get the point. He's not going to conform to it.
Issue a violation.
Yeah, I was gonna ask, do you issue an NOV or something?
That's the method.
At
Do
the
a fire
time,
inspection.
I would say the administration that was here had told us not to do that at that point.
Well, I wouldn't remove an exit because his behavior, he's blocking it. You give him a violation and then you send him to court and fine him.
Well,
Yeah, but I would remove
ultimately, the building inspector, Meek, issued a multiple violation notice of violation in April of 2023. And that's what led to, I believe, the action here today. So there was a positive outcome from the notice of violation. So I want to add that as far as it relates to a notice of violation being issued, we were instructed to work with the occupant and business owner. But ultimately, it led to a notice of violation because there were multiple infractions of village and state building code and fire code.
Okay.
Okay.
Yep. So Mr. Vasquez, you're advocating for that rear exit to be removed from a legal exit.
Yes,
Exit
because
signs off.
the reason there are multiple aspects to that exit. There are staff that are at the coffee machine. They're doing food prep, no cooking, and the addition of combustible materials in the path of egress on a regular basis would lead to questioning whether that is a viable second or third exit.
I can address that one if you have.
Feel free, yes.
Go ahead.
Jump in.
So But I don't know, again, April of 2023, a lot of this there was discussion of all this, so, I completely understand that, a rear exit should not be utilized for storage, and they've done other things, and they do get deliveries from that back exit, and I know that certainly all businesses temporarily, they may do stuff, they've gone in and observed things, I'm not questioning what they've observed. My sense is though, is that, and what my takeaway from the meetings were that they don't want their enforcement mechanism, they don't want to perform their enforcement mechanism by putting certain constraints on the client. I understand the history, but there's a little bit of a mixed history here as far as whether that's a legal exit. Now, if it's not a legal exit, how am I using that? What am I putting there? They've observed things. They've never really recognized that as a legal exit, they're saying, with the number of occupants in the space, but yet, they're not giving him the opportunity to use it as a legal exit. I think it's their job, again, they do an assembly, or they go in there, to write up whatever violations. As far as I know, since whatever time, I had a very extensive, engagement with them last year. And I'm not aware that there's been any violations since that time, because the table is 2 feet from an exit, or a guy puts a sandwich sign outside or whatever, business people, I understand they're trying to drum up business, but, move the sign, do whatever, write them a ticket. I'm not saying that, but it looks like we have to look at what's really stake here and what can be brought into compliance just by having a posted seating chart, or, they come by and they observe something, write the guy a ticket. As far as I know, he's been operating that location 50 seats since last year, and he hasn't had any violations, and he's put all these things here. All he's asking is to reintroduce some of the seating that he's been using for the last 20 years. I don't think it's fair to put an undue burden on the applicant, because they may not want to enforce it. So whether, I understand village politics a lot, but if somebody is telling them not to write a violation and you're a fire marshal, I don't think that's right. Or if you're a building code inspector, I understand there's pressure from higher ups, but they have a job to do, and uphold a certain standard. Not enforcing that standard because somebody told you to, write the violation, write the NOV. So
I think the key point is they shouldn't have to enforce the violation because there shouldn't be any.
absolutely. I think that
If it's told to maintain an aisle width or tables away from the door, then that should be maintained, and it shouldn't be.
No, understood. I understand entirely. But there's where a lot of this started was that we wanted to get an accepted table layout, and there never seemed to be a consensus. And then when the consensus came about, their solution was, or they can speak on this, is bolt down the table. So I don't think they had an issue with the tables. They kind of had discussion about the number of seating. I don't necessarily agree with them with this, take the 50 occupants and then you have 6 or 7 employees, and then the rest of that is the number of people that can occupy the space. I don't agree with that evaluation. On occupancy, we've always done it by the number of seats, and because the employees are in the kitchen, they're not in the dining room. The guy's making stuff in the kitchen, but not in the dining room occupying that space.
Yeah, it's net floor area of the assembly space.
Yeah.
And you have loose tables and chairs, which is 15 square foot per person. So as per that, without getting building official latitude,
Yeah.
what's that number?
That's like 40, it's 40.
Okay,
Yeah.
so you want to get another 25,
For increased occupant load based upon.
but you're not improving the exit situation. That's where I'm struggling.
We're looking to improve the exit system. We're looking to improve the exit situation according to the original plan submitted. And we want to make improvements to utilize that rear exit. And, we were told.
What can there be? What improvements can you make
Well,
to?
the improvements could be the things that we outlined, which is on the plan from August 5th, which is certainly to have a clear path marked, have limited access to the kitchen and dishwashing area. And certainly anything that leads to an exit, we never want anything stored in that location. But we want to be able to maintain that. If we have a set of an acceptable layout and acceptable construction standard that we can build and design to, let's implement that. And then, I'm not saying that we want to have this as a continual problem, because, we recognize that this happens in small operations on main streets and downtown area that, people want to kind of put in as many tables they want. That's fine. This is a fair amount of tables, 60-something seats is a fair amount of seating. I think that can be maintained with little oversight by the fire marshal. I know that they have a history and the client was not happy about removing seats and other things and whichever else, but I think that there's a viable design alternative here that was originally intended with the seats that have been in there for 20 years. And let's make that approach work. So
Is there a fire separation between the cooking area, the kitchen area, and the rest of the restaurant? You have a wall between the dishwasher and the walk-in box, and then it wraps around the stair. And
I'm
then,
not aware that it's anything more than 5/8 drywall that's in there.
Okay.
I'm not aware that.
and it's open, the stair is open to the
stair
upper
is
level
open,
kitchen.
Yeah, there's no door.
Can you just explain how it's hard to tell on the plan, how the residential above exit there, is it above that kitchen?
There is actually, there's a fire egress diagram for I'll call it the basement level. It's like a half level down. A lot of these buildings on Main Street, the rear parking lot is
It's a
about a
great
half level down.
Yeah,
So they half level down to get out to the rear municipal parking lot. It's also half level up to get to the kitchen. On that lower level, tenants go to their apartments from the rear of the building. So if you look at that, there's two doors. One is the exit for the restaurant, the rear entrance to the restaurant. The other one is a door that leads up to the apartments.
okay. And that's separated, that fire and construction, the doors?
Well, it will, if it isn't, I gotta verify, it was supposed to be, but if it's not, we gotta verify that it will be, whether it's adding additional layers of drywall and making sure that's conforming, but the intent is that it should be.
I don't know this question, but do you guys know what the minimum amount of heads for a limited sprinkler can you tap off domestic?
No, because it
Is
goes.
it like
by-
10 heads or less? I remember somebody saying.
No, normally when you do 10 heads or less, it's just a relocation or you're adding, in this type of situation, you have to do the calculations on the water flow.
Okay,
Look, putting the sprinkler system in, if you can come up with the calculations, resolves this issue.
well, you're talking about the entire building. I was talking about limited in the kitchen area to try
Trying an
and.
addressable fire alarm.
Yeah,
Look, over the years, it appears that there's been an issue here.
Yep.
It appears that the village has gone,
I
both, it's just tried to work with this, but putting people in the position at this point where how do you ask for the increased seating when you have an issue with the fact that the door's being blocked and you see that in a lot of restaurants. I get it. They're working hard, they're paying, they're trying to survive. I get that, but still it doesn't mean that you lack life safety. That's the most important thing. When I go in a building, first thing I look for is where are the exits.
So I just want to say over the years, this restaurant is operated. Previous fire marshal, Lee Brett, was in there many years, never took issue with anything in this, never issued a violation. Not saying anything else or casting opinions. I've had extensive discussions with these fire marshals. They have the right to put whatever level of scrutiny on this. This has only been a recent matter. This is only a recent matter. When we started putting this stuff together, it's only in the most recent years that this has become an issue. So I'm not saying whether anybody's looking, whether they're doing their job. I respect that, but this has not been an issue for at least, 14, 15 years until we went to the village and said, hey, we need to like get a CO for this space because one was never issued. And then at that time, things were there, but fire marshals have been in there yearly or biannually, whichever, never an issue. I don't believe there's any record of any violations until we started making inquiries about this space. So I'll leave it at that, but I understand, listen, fire sprinklers are not easy things to do. What I'm trying to get at is that I think that we're looking for the increased occupant load, when we can provide a layout. Basically, they didn't want to accept that layout. And we have a space that has 2, potentially 3 exits from it. If we include the rear and we fortify that rear exit and verify it's conforming, fire sprinklers is a big, you know, it's a big request. I'm not sure if it can be technically even put together because it's just my experience on Main Street there with the fire service.
What's the locking systems on the doors in the front of the building?
It's, you know.
Are they break bar or
Yeah,
bolts?
yeah,
They're on panic
yeah,
bars?
as far as in a panic bar, yeah, I'm pretty sure it's a panic bar.
I mean, the state code has that remoteness in for a reason.
Mhm.
So I know you're close, you're not quite there. So there, if there's vehicular impact at the front of the building and there's a car fire.
Yeah.
And you don't have that back exit, what do people do?
Yeah.
Because they're pretty close.
Yeah.
I'm not gonna try and, are you gonna try and run around a car that's on fire to get out the other exit?
Yeah, no, I
So
understand.
when you're going up to 60-something people.
Yeah.
You know, I can't speak for the other board members. I really think you need to maintain, I'll climb over boxes to get out.
Yeah.
If there's an exit out the back.
Yeah.
And then it's tough to control behavior. I understand the fire marshals, but if, you know, there's annual inspections.
Yeah.
And you can do random inspections.
Yeah.
And then hit the guy with violations till the cows come home. If he wants to pay.
Yeah.
Because he's not behaving properly to keep the building safe.
Yeah.
But as far as the provisions that would be put in place to make this an acceptable variance.
Yeah.
We need to talk that out.
Yeah.
The board.
And that's fine. I would like to put forward that again, if we can, we definitely would look to fortify that rear exit to whatever standard there may need to be. Whether it's even the creation of a door into the kitchen or something, but you know, that was the original intent, which wasn't questioned by the building code official at the time, Kevin Kubek. He was the engineer and building inspector, reviewed that with him. He found that acceptable at the time. We went clearly 15 years, no incident. It's only until this recently came up that, you know, there's been a lot of contention over it. So I would, you know, respectfully ask, sprinkler systems aren't an easy thing. Not that there shouldn't be, but if there's these additional exits and we can address that life safety and exiting there, that would be our preferred route. Certainly adding in a central station fire alarm system, you know, monitored fire alarm system. If there is some sort of limited sprinkler system for that path, you know, I think we'd be amenable to that also. It's just the entire building's a tough.
Yeah, so you're looking for 65?
Yeah, we're looking for 65 or something that's 65, but I would say
65.
It would be 60 was what the fire marshal.
Well, I was gonna go to those gentlemen in a minute, but I wanted to get you on the record. You're desiring 65.
65 seating,
65 seating, yeah.
which means
Occupancy.
70 plus total occupancy.
Well, the building code doesn't look at that, right?
Yeah.
Does it?
Yes, well,
What's the commentary say?
there's.
Identify, I'm sorry, please identify.
I'm
who's
sorry.
speaking.
This is Courtney. The building looks at a fire area. And I'm not sure that a fire area is defined within this seating area at the moment, a proper fire area. And so it could be expanded, the fire area of this building having an A occupancy could be expanded to the whole building, or it could be expanded to the whole story.
Yeah,
in that particular building.
Yeah, I would consider the fire area the whole story, not the whole building.
Correct, okay,
Right.
so what I'm saying is that the trigger for the sprinkler is based on the fire area, not just the seating.
So if we had a seating area of 98 people,
He
and
probably
then the
would,
total fire area load was 104, it's gotta put a sprinkler in.
and that's correct.
Okay.
How many employees are in the
I
building?
think it's somewhere between like 6 to 8. They have maybe a couple of 2 or 3 wait staff, and then between maybe 4 or 5 people in the kitchen.
All right, so I'd like to go to the village folk. Guys, you still with us?
I am still here. It's Todd.
Okay. So the question, because it's very important for you guys to weigh in. If he's looking for a 65-seat restaurant, what would you guys want to see for that to be somewhat approvable?
As we discussed with Mr. Morabello, and he agreed with us when we had our meeting at 88 North Country Road in Port Jeff, if he had fixed seating, I could see where I can get it up to 60,
And
maybe.
if he doesn't?
Then I'm going to stick with this strict state calculations of 15 square feet per person. Listen, I'm a patron. I go there. I've eaten there many times with my family. And I know that the movement of tables is quite often. And I'm afraid that if he's allowed to go to 68, you're going to have the aisle access ways are going to be blocked. And God forbid there is an emergency. It could be the meaning of somebody living or dying in that building. It is an old building. I know the building fairly well. It used to be the old firehouse for Port Jeff. It's like I said, it's just there's too many things that I've seen there that are constantly in violation. Not as of recently, because we were told to stop because he was making complaints that we were harassing him. So we stopped under advice from our previous boss. And as of now, I have a new administration who is just do our job. So, like I said, I really can't. I wouldn't want to put my name on it and say that it's good and that he's going to comply because I know everything that's going on. He had outdoor dining last year in front of the building, which he had no permits for. And those chairs were blocking the means of egress. And like I said, I got pictures of that too. It's one thing after another. I mean, I wouldn't want to go to a business and have to enforce it every day. And I think that's what it would come down to be. And that's not the way for us. I don't have every day to go to a restaurant and check that it's in compliance.
Yeah, may I state that the outdoor dining permit process within the village exacerbates the egress issues because of the non-remote positioning of those 2 egress doors, and the business owner constantly placed chairs and tables within close proximity to those 2 egress doors. So that exacerbates the whole issue with the proximity of the 2 egress doors on the same facade wall. So I wanted to verify what Todd said, but also add the fact that outdoor dining in the small area of exit discharge creates additional issues. Thank you.
So is there like a cavalier attitude with regards to compliance?
No.
Because I mean, if he's in violation and the fire inspectors, issue a violation,
Yeah.
there shouldn't be this constant
No,
policing of behavior.
I'm not aware, they can answer this, I'm not aware any time in the last 8 months since this outdoor seating has been issued.
Yeah, because now they're
Talking
reluctant.
about, there's been a lot of focus and attention on this applicant. There was discussion about seating layouts, because listen, COVID, people were eating outside, right? There were a lot of outdoor dining. You had chairs back and forth, what's acceptable, what's this and that. He would lay something out one day, they take some pictures, that's not acceptable. As far as I know, from the summer, since we had a discussion, there's been no outdoor dining. And maybe out front, they have maybe a couple of tables not blocking any exits. So again, we're talking about something from a year and change. He's been compliant since then. So that means I take that 15 years, no issues, fire marshals, anything else, a bunch of stuff coming there in the last several months. He's shown that he will comply to whatever they want. He hasn't had more than 50 seats in there, no issues outside dining. They're talking about something that happened for a brief period of time, and they were going in there, and because they felt my client was a fly in the ointment, they needed to address it. They were doing their job. 100% agree with
I
them.
understand their reluctance to approve a higher occupancy, because it doesn't appear to be a law-abiding, business owner.
Yeah.
But if he is,
He has been, I'm gonna say he has been, since he's been made aware of what the requirements are. He has been. I don't know any instance of any changes of tables or anything that's going on. I'm not questioning their observations.
Mhm.
It's just that once he was made aware of what he has to do, I'm not aware there's been anything. And they could see the outside of the building. And I had a lot of back and forth because the client was even confused about where he could put things. Somebody to the south of them put some outside chairs. They thought they were his chairs. It was another business operation that reads tarot cards or whatever.
Yeah.
So there's like a lot of scrutiny on it. So, I'm like, listen, there's been nothing that's been happening on here since he's been made aware what the requirements are. As far as I know, since we started putting this application in, we had a series of things back in July and August last year. Everything's been
but
according.
you
to-
understand why they're reluctant, why they want you to bolt, because it's hard to control behavior.
Yeah.
And it happens a lot in a lot of restaurants where it's overcrowding and constantly have to police the
So.
businesses.
So let me put this in another perspective, and this is where, again, I had a little bit of concern. Certainly, we're asking for interpretation, maybe mitigating things, whether it's fire alarm or other things, or reinforcement exits, or whatever this board deems necessary. The owner is, he's close to retirement age. So as much as he has his business, it's a successful business. He wants to be able to operate it, properly and within whatever parameters are accepted. And, if someday in the future, we're gonna set up for how this place of assembly is operated going forward forever. So I understand that maybe there is, I don't like to use the term, some personal angst because the client is a business owner. We all know them. And maybe he's approached the fire marshals in maybe not the most respectful way. I don't know all of the back and forth, but for the majority of the existence of this operation, no issues. Couple of years, some issues, scrutiny. He's clarified, brought him in there. I agree. We were at a meeting and I said, hey, I was there with them, screwing down the tables. I thought it was, I didn't think it was a bad idea, but I didn't operate the business. When I went back to my client, he said, I can't do that. I clean this place every day. This is not something I can agree to. So that's where it kind of ended. And I have an email from the then head of the building department that said, listen, we just don't want to make the call on this. We want to be able to, again, they're not comfortable. They've expressed that. Want to go to a higher authority, present your case to them. We're not opposed to, I have an email. He wasn't opposed to a higher seating count. They just didn't feel like, because of the most recent things that they could, make a determination on it. So that's where that stuff kind of came.
What's the
from.
maximum, is it 7 square foot
7 square feet.
in the assembly?
Yes.
And what number would that yield?
80.
That's
80,
over.
yeah.
Okay,
80
but the code says.
I
it's up to the vote.
apologize, gentlemen. Can we repeat that? You guys were speaking at the same time. I'm sorry.
I think Mr. Coordination said 80, or somebody said 80.
You would ask.
I asked what the
what's
maximum-
Maximum the code would permit in a space like this.
Mhm.
It would be 7 square feet per person, and that's standing room, basically.
Yeah.
only.
I have a question for the village. If an addressable system were to be installed in the entire building, would that have an impact on your decision to keep it at a lower number, or would it be something that you're willing to allow a higher number?
So let me speak first. We do not object to the increase in seating as long as an unobstructed path of egress is maintained and additional conditions are proposed that would increase the safety factor for both the residents above and the general public in the assembly space. So it's not the building inspector, me, I'm not opposed to increasing it. I would let the fire marshal speak now. But again, as long as the additional safety factors are provided as proposed and accepted by the board, and again, demarcating exit areas, having fixed seating and tables in uh, primary exit areas. These are conditions. So we're not opposed as long as we can all agree that there's a factor of safety. Okay, and I'll let Todd speak now. Thank you.
Yes, I agree with what Mark said. I'd have no problems with allowing him more uh, persons to seat if he did have some other safety features that I knew could help somebody get out of the building safely if, God forbid, something happens. I would not be opposed to, especially even a sprinkler system in the even in the dining area. I think that would be a good idea, including the kitchen. It's something definitely to look at.
This is Courtney. I know for businesses, like you said, they want the flexibility to, for a party to have a different seating arrangement, in one area. Would you be amenable to them coming up with an alternate seating arrangement that can accommodate that? With the proper aisles and exits? Is that something that you would be willing to accommodate?
I think it could be done. Like Mark mentioned earlier, though, too, is we think by the exit ways, that's where we need something put in place so that he cannot move stuff into that area where it blocks the egress. It makes it much, it would make it much safer knowing that there was something secured in an area so he cannot block that area.
Yeah, just to address that, so, one of the things that we had looked at was, whether, there's a knee wall or something that's put 3 feet off of an exit, so obviously, we talked about some things, even like if we needed to further divide the dining room. So one question came up was, well, we don't recognize this as 2 dining rooms because there's this openness, so there had been some level of separation division, but, that second exit, I mean, a clear thing could be that a small, 3-foot high wall, not that I think that he needs it, but, there are some mitigating things that can be done. If that's their concern, is that second exit out of the other dining room, because that's clearly an exit, out of the space. We show a table there that has 2 seats, okay? So if that table was pushed up against a low wall, then certainly I couldn't have seats on the other side or couldn't be anything else. But there could be some mitigating factors to address what their concerns are. So I just, the sprinkler is a tough, listen, it's always tough. I'm not saying to get around the code, it's just the combination of being an older building and retrofitting and doing those things. And then my experience, they may be aware of it too, is just that section of Main Street is the water pressure and other things are issues. And I've seen it have issues on other buildings. So that's my thoughts on that.
Erica, you want to weigh in at all? I know this is your area of expertise.
So, I mean, it's very interesting because I actually took a class yesterday regarding emergency exits and behavior. And it's just so easy to get used to going back to the behavior that you have. So unless there is a change in behavior that those exits in the back are maintained open, it's never going to be a viable exit. So, you know, like it's got to be a change in the kitchen. It's got to be a change in that area so that exit is maintained open as a method. I mean, I live around the corner. I've eaten there. It's a tight space, and I know that, you know, like every time I've been in that space, it's a tight space to be in that restaurant. And I personally never knew about the exit in the back. So, you know, but I wouldn't have known that it was there. But if it isn't changes in behavior and maintains it as an open area, that is, as we talked earlier about, you know, about where the enforcement is, it's not going to happen, because it's just a part of human behavior. So, you know, where's that step in ensuring that that exit has always been maintained? So the only other viable option is a sprinkler system for us to ensure that it's protected inside the building for the people both upstairs and for the patrons using the building. So it's not a question, it's just that's, you know, that's your option that you have.
But I think the mitigation of behavior is just to, again, to harden that exit, like to outline it, whether it's, you know, whether they're aware of it or not. Again, there was a point that they were asked to not utilize as like recently, and so exit signs taken down. But there had been an exit sign there for years, and the rear exit sign was taken down. Mostly because we were looking at other options. We were saying, well, we have 2 exits out the front, certain distance separation. You know,
But I mean, I hate to cut you off, but the reason why, if it's not a viable exit, it can't be identified as an exit such. So that's where people get caught in fires, is that if it's, everybody thinks that there's an exit there and everybody lines up and it's not big enough, it's not, you know, there's no egress there and people get caught there, then that's where the trouble lies, right? So that's why, you know, if it's not viable as an exit, then it can't be maintained as an exit until it becomes viable.
yeah, I understand, but I'm proposing that we design it to be a viable exit. The intent when these plans were first reviewed and submitted to the village was that be a viable exit. Now granted, you know, that's what we want to use it as. We want to harden that, define it whatever way it needs to be, and have that as a viable exit. Many people that go into a restaurant, I understand regulars going in, but most people that go into a restaurant, they've never been there before. I got an exit sign in the front, I got an exit sign in the back. Something happens, we're relying on the signage and the emergency lighting and the pathway to that exit to be there. I think there's a solution where we can do it without putting in sprinklers. That's my opinion on it. Certainly it's not, you know, easy, but I think that if we design it, we come to an agreement on that, we can harden and design it, whether it's partitions, openness, fire rating, whatever needs to happen, limited sprinklers in that area. That would be my recommendation on it, but I understand, I'm not sure if the behavior is people who are used to the space, or we're talking about the behavior of the owners. I'm not sure what point, Erica, you're talking.
So the question is though, is that do you have a drawing now that you can present to us that we are able to make a decision on now that is it's a hardened exit?
Yes, yeah, I have a drawing that's in front of you. It had been initially reviewed when we submitted and we had added in that hardening, I'll say hardening, to that area, but certainly further conditions can be added, or if we need to come back to present that, we can do that also. But we basically, you know, showed a clear path, an outlined painted path on the floor for that exit. Restore the exit signs that were there. We added in gates or barriers into the 2 other areas of the kitchen because they exist. One exists entirely on another level. You know, if I'm presented with, I go through an exit door.
Can I interrupt you for a second?
Sure.
Do we have those drawings?
Which drawing
Yeah.
is,
A0.
I got all these like tags all over it, I guess when it converted. And I got all these, I can't read the sheet number.
So
It should be
A0?
Mr. Haynes has that.
Yeah.
A0.
Would be A0, revision 7.
Yeah, I don't have that.
Yeah, for some reason, when this was,
What was the last?
sent to us as a PDF,
8/5/20.
you got those things
No,
too.
we're talking over each other. I have that. We don't have it.
Oh, I have something that says 8/12/21, it looks like.
It's
probably. I have a few extra copies here. I think. And it's a little bit small. I have a full-size copy here.
Bro, what you want, man? No, I got it, thank you.
Can I ask a question to Mr. Mirabello? Are they gonna widen the hallway then that goes to that exit? Cause it's not, that's even a little smaller than code.
We would certainly widen it to any sort of conformity that needs to be. Right now, there's a 3'8" wide stairway, which empties into a 4'2" wide hallway that leads to the rear exit. If there's something that needs to be widened or anything done, any improvements or fire separation, whatever needs to happen, we would do.
The only reason why I'm asking Mike was because when we went there and measured, it was under 3 feet wide in the one spot at the top of the stairs, I believe. It was like 2 feet, 9 inches or something like that. So it wasn't even 36 inches. How would you do that? How would you fix that with the kitchen there?
The only thing that I can see is that, there are some chase spaces that are adjacent to the stairway. I think that certainly there's space there to work with to widen that if necessary. And I'd have to check those dimensions. Obviously, we're showing something wider.
All right, just to summarize, not to step on you, you're putting a door in front of the stair to go up to the kitchen. I guess that's a separation, but it abuts like a storage table. So you're putting a wall there at all, or?
It's actually, I have it pulled off as, I thought I had it pulled off maybe on another page as like an access gate. Yeah, proposed 36, it's on A1, 36 by 36 inch high self-closing swing gate with kitchen only, not an exit sign on that gate. So that's what that is. So it's basically, it's a posted gate.
And what is that doing for you? That's just preventing.
That's just preventing free flow into that area. So if somebody needs to come down, they can do that. You can still see that area. But the table could be removed and I could put in a door. I could do something like that if need be. Where those gates are, if that's something that's that higher level of hardening, we could do that.
So I don't know, what we do we punt it to next month and they come back with a plan that the village is comfortable with, or do we deliberate and see if we can put some conditions together that a possible path to approval with conditions?
I'm willing to entertain it. Yeah.
It's sort of like rhetorical for the board,
Yeah,
but
my bad.
I would adjourn it and come back.
you would.
I apologize. I did not hear that. I apologize.
I would adjourn it, Rich, Ravon, come back, try to work it out and come up with a plan. I still believe that the addressable system is probably a need.
I mean, we can condition an
Yeah,
approval with that,
that can be,
Yeah,
but as far as getting a cohesive plan,
right.
sorry, Andy,
Yeah.
you were talking.
no, I was just agreeing with Rich that, yeah, but that's an easy,
That's an easy one. I mean,
Yeah.
the cost factor is, I know it's more money, but at the end of the day, it does provide a higher level of life safety in this building, which is needed. It's an old building.
Yes. Yeah, I think that, that's a reasonable, they're not inexpensive either, but that's a reasonable request on this, to have that. And it's electronic, so that's not a
Central Station.
central station, that's not a hard thing to implement.
I mean, I really respect the enforcement boots on the ground, like these guys are in it every day. They're, have this responsibility to make sure things are maintained compliant.
Absolutely.
I would like to know if there is possible alterations that can be made that they would be acceptable to that rear exit, being a viable exit.
They would be happy to entertain those also, yeah.
So I guess that would lead to whether or not we do adjourn, so you guys can kind of hash it out and then come back, or are we confident that that could be achieved? And we can go deliberate and come back with conditions, with one of those being you need to work out a cohesive plan with the fire marshal and the building inspector on how that can be a legitimate exit for you guys.
I'm open to either one,
Okay.
so I certainly would be, we want to be,
Okay.
expedient, but we've been doing this for several months, 7 months now. We submitted this in August, so,
Okay.
quite frankly, another month, if needed, is fine, unless they have some, input here.
The problem with, expediency, if they get out of this hearing, there's no guarantee that they will be able to be admitted on the next.
No, yeah, I understand that, yeah. They have some stuff to work out.
Yeah.
Hey, Lynn, do you want to have a say on that? Do you feel we should have them come back? Or are we okay talking this out?
You know, I think I will more like to have to postpone the meeting and have them to come back. And with the much later information that we be judge the case more easier.
Do you want to make a motion or do you?
I'll make the motion. To adjourn.
I'm not.
I apologize,
Mr.
gentlemen.
Pavone makes a motion to adjourn, and we're looking for a second.
I'll second.
Mr. Hames is a second. I'm not in favor, so there's one opposed.
Peiling, aye.
Aye, so we're gonna adjourn. Erica?
I'm in favor of adjourning.
Okay, so we have a motion to adjourn. Please take these notes, get together with the village. There's gonna probably be some conditions anyway with enhancing the life safety with regards to fire protection features like Mr. Pavone mentioned. And try and get this exiting and this number down to where it's acceptable to the local, because the local is an important voice for us in making a decision.
So, just a question on this,
Sure.
really more a technical matter. A lot of the application, centered around, interpretation of an increased occupant level there, which was under like 1004.5.1, which is a section of code that allows increased occupant level. It says by it has to be, approved by the code official.
Yep.
So the question is this, if I meet with these gentlemen again, because they've heard your input on all this, and they have a resolution, to this, because this all stems around what they approve as a seating layout. Do we come back?
The notes I had-
Board side.
The notes I had was fix the seating, the bulk.
Yeah.
And then there was a follow-up on Mr. Pavone's question that it sounded like they were amenable to whatever we decided was a good enhancement to approve.
Yeah.
So I think that's why I oppose. I think we could talk it out and maybe put some conditions in, but there's not a plan that the board members are comfortable with.
Yeah.
So,
My question would be, again, it's unusual, is that if I go and meet with them and they say, yeah, based on these conditions, based on these items, and now that we've heard the questions from this board, they're the ones that ultimately have the charge of approving the layout. They decided not to approve the layout we had, and we came to this board. But if I go to them and we put in our conditions and again, just to save your time also, we would.
And that's a letter stating that you're going to withdraw the matter and then so that you've come to a resolution with the village. As long as the village is going to agree to that.
Yeah.
And not come back another few years later and say,
Yeah.
we never agreed to that.
Yeah.
That's something between you and the village.
That's my only point.
and if I was you, not to say, because I'm an architect as well, I would vet out the cost of a limited sprinkler system in the kitchen.
Absolutely.
I don't know how many heads, it depends on pressure, but I know Nassau County, it's embedded in the fire marshal's
Yeah.
code.
It's different.
And if you can get a limited system in where you're most prone for fire.
Yep.
I think that'll help, the safety of the
Very good
patrons.
Okay. Yeah, definitely, we much more prefer to work it out. We came to the table with them
Great.
before, and then we hit an impasse, and that's where we are.
Okay,
So
My primary concern is maintaining the 3 exits,
Mhm.
the 2 in the front and the 1 in the back.
Yeah.
And I think the central station monitoring, although that is good, but it doesn't get people out quickly. But, yeah, that should be done too.
We're gonna big garage door in the front, you know?
That works.
We're still on the record, right?
Yes, we are, and I wanted to thank
Okay.
the guys from the village. I appreciate you participating. We don't get this all the time, and really appreciate your time. And then hopefully you guys can work something out.
Thank you. And I just want to add to Mike's concern. You know, the denials have already been submitted and forwarded to the state. What are we going to do? Make up a new code? Once this is vetted and resolved, the permit modification process occurs, and ultimately leading into inspections and a certificate of occupancy. So I don't get the logic there, but okay.
Huh? I didn't understand. Mark, this is Courtney. I think what the petitioner is asking is if he can go back to the town, you have the authority to approve more than the table 4104 point whatever of the building code, part of the building code
Okay.
allows. You can go over that. If you can work out with him how to achieve that, maybe with the improvement of the third exit out of the rear, you know, he's submitted something that the board, you know, isn't comfortable with approving at this moment. You raised questions about the egress openings, the size of the exit of that rear thing. But if they can agree to something, if you and him can come to some agreement, you know, maybe involving partial sprinkler, maybe involving smoke detecting alarm device, then, you know, they wouldn't have to come back to the board.
Okay, but my concern was that the conditions that would be presented to the applicant as conditions of approval, we would not change those conditions or make them more excessive. In other words, vetting and acknowledging and coming up with the conditions that we can all agree to would be a design modification, permitted, inspected, and see a vote. The fire marshal would not go back after this process and, you know, create additional questions. That's what I was getting at. I kind of read that a little bit, and I didn't agree with that. Okay. From
Mark, if I can address?
Yeah.
Still on the record.
Yeah, Mark, what I think what they're talking about is that if we can go back to the table, they've brought up some matters here today. We want some clarification on a plan because it may not have been in their record. And if there is something that may address your concerns, then there may not be a need to come back because ultimately we're before this board because, you know, certain reasons, but also the number of seats and the code does allow for increased seating, but it's only if you approve it layout. And if there's issues that we can't come to terms on, that's why we're here, that we come back and, you know, whatever we do. But it's worthwhile that we at least have a follow-up meeting with everybody, yourself and the fire marshals, and see if this can be rectified. Then we don't have to take any more of this board's time to come back.
Yeah, you know, you got a
Okay.
remoteness issue, which doesn't meet the code.
Yeah.
So you only need 2 exits.
Yeah.
So that back exit, I think we've been focused on a lot.
Yeah.
But you're going through the interpretation of going to a kitchen.
Yeah.
So you may need to come back.
Yeah.
To seek relief for those with an increased number.
Yeah.
Or if you rectify those with the village, you don't need to come back.
Okay.
I'm going to throw one last thing out here just because you mentioned the remoteness again. And you have seen it, and there's probably been several things written about the remoteness between those 2 front exits and their separation. So I've been to code classes where they say any part of the measurement, and you can see I took the liberal side of the interpretation on my drawing, which was the outer edge of the doors. Some people want the inner edge, some people want the center line. I don't mean to make light of any of this, but if I had my little benchmark, because there is an alternate path which didn't come up in the discussion, was shortening the dining room. If they were saying, listen, we're at 60 seats and my client was comfortable with 60 seats, a method would be to shorten one of the larger dining room and change the diagonal distance of the space, and then I conform. That's another method, and I'm at 60 seats, and then a lot of this may not be an issue also, and that might entertain another thing, but a lot of that does come down to where I take that measurement. So not to put it on you right now.
I've been a code guy for almost
Yeah.
30 years.
Yep.
Ultimately, that interpretation is up to the local.
Okay,
It really is, how they consistently view it and how they consistently do it.
yeah.
And then you can dig into the comment, and if there's an appeal of their decision, you come and say, we appeal the code official's interpretation
Yeah.
of how they interpret remoteness,
Yeah, yeah.
and then we can look at it.
Okay, all right.
I have a tendency to be a little conservative because it's life safety. You know,
I always feel like a center line.
I see you don't have accessibility 100%.
Yeah.
We're focused on life safety.
Yeah, yeah,
And,
I almost feel like a center line is a good measurement. But then I go to my AIA code classes and they tell me,
Yeah.
you can go to the edge, so that's where I start.
Sprinkle the building, your problems go away.
Yeah, of course, absolutely.
Well, Mike,
That was my last comment.
Mike, I look forward to talking with you in the very near future, so maybe we can come up with something.
Always, thank you very much.
Thank you, Fire Marshal Stunt. Okay,
Thank you.
hearing is closed. Thank you, everybody, for the time.
Okay, we are off the record.
We take a.
Yes, we're off the record.
break.
Yeah, okay, on the record, here we go. The second hearing is in the matter of petition number 2023-0496. The petitioner is Joseph Gallinaro for Mr. Daniel Labrizzi. This petition pertains to an existing detached three-story, one-family dwelling. Is it really three-story?
No,
One family,
No, it's really 3 levels, but not 3 stories.
it's a two-story, one-family dwelling of wood frame construction. The dwelling is approximately 2,590 square feet in total gross floor area, including basement space and garage space, and is located at 16 Leamington Street, Lido Beach, Town of Hempstead, County of Nassau, State of New York. Petitioner is seeking relief from 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section AJ 801.2, which states that additions shall comply with the provisions of this code, except where required by this section. Unaltered portions of the existing building shall not be required to comply with this code. And 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section R 322.2.1, which requires that buildings and structures in flood hazard areas, including flood hazard areas designated as coastal A zones, shall have the lowest floors elevated to or above the base flood elevation plus 2 feet, or the design flood elevation determined in accordance with sections R 322.1.4 through R 322.1.4.1, whichever is higher. The petitioner wishes to construct additions to the first floor that are structurally connected to the existing dwelling and are below the design flood elevation. Okay, Mr. Joe, you have the floor.
Thank you. Thank you. Good morning, Mr. Chairman Peterson and members of the board. My name is Joe Gallinaro. I'm the architect for the project. The office here at 143 East Park Avenue, Long Beach, New York, 11561. I'll be representing the Labrizzi family. The subject property is, as mentioned, in 16 Leamington Street in the town of Hempstead, County of Nassau, State of New York. Again, requesting a variance to build a lateral addition in a flood zone. It's determined that this property was not, the size of the addition was not a substantial renovation, determined by both the town and the state that it would not be a substantial renovation, each of them doing their own calculations along with us in their own particular and separate different ways. Both came to the conclusion it's not a substantial renovation. We're proposing a 2-story addition on the north side of the property. The addition is to enlarge an existing very small kitchen, as well as to build out a main bedroom suite over the top of the 2-story addition on the north side of the property. This addition will allow the family to grow. The family is currently 4 of them. They also house a lot of extended family come to the house, and what they have right now is smaller than what they need. In looking at the project at first, we decided that if this addition was to be FEMA compliant, which although it would still need variances from the town of Hempstead for different reasons, that we would need to build this kitchen level up 2 foot 4 inches from the existing height, or the height of the existing kitchen, which would require 4 steps, handrails, and so on, which seemed to be a way that would disrupt the flow of the way that the space would work, especially since we have a kitchen to a dining room and a living room. Having it all flat on one level is an important thing for the family. Secondly, the cost of construction would be increased substantially if we had to elevate the building from the foundation typology, the staircases, and so on. And there would be 2 sets of stairs. There would be another set of stairs on the second floor, obviously, to get up in there, into the second floor main bedroom. It is, I think, worth noting that the top of the first habitable floor, the existing first habitable floor, is 11'8", and the base flood elevation is 12 feet. So it is pretty close. It's only 4 inches away, although the design flood elevation would push it up another 2 feet, as mentioned earlier, to 2'4" required. So analyzing the entire proposed structure, as well as along with the code enforcement official at the town who supported this project to be viewed as a routine variance, we're here before the board tonight requesting that they allow this addition for this family so that the house can function on a high level.
Thank you, Joe.
Thank you.
What's the space underneath the addition?
Crawl.
It's a crawl space?
Mm-hmm.
Okay.
Crawl space, it would be on grade. We'd have flood vents.
That's what I was getting to, yeah. You have access to that? It doesn't look like it's on the basement plan. Crawl space access, how deep is the crawl space?
The crawl space itself, I would say, so the highest adjacent grade is 9'7". The top of the first floor is at 11'8". So it's about, 2 foot difference than adding the structure in. So we don't have much space under there, but we would put a rat slab. It would be aligned with the outside grade, and we would have enough to get flood vents in there. Yeah.
That's what I was alluding to, yeah. Okay.
Is that it? These drawings are very limited. You didn't put any sections in this submittal. So it's very hard to see some of this stuff.
You applying for any local variances?
We have, yes. We're currently with the town of Hempstead. We're waiting for a date to be seen before that board.
And what are the zoning comments that they issued?
So this, the requirements for the variance would be front yard, because there's a proposed patio as part of this application. The addition would not require a variance. There's an elevated AC platform and generator, which gets close to the side yard, which requires a variance. Excuse me. And because the lot, even though it's 6,500 square feet in a 6,000 square foot residential B district in the town of Hempstead, larger, it's the Lido Dunes, which has everything rotated. Their lots are wide and shallow in depth, where the zoning is set, so it's 65 deep by 100 wide, where the zoning is really set for 60 wide by 100 deep. So we always end up with this area always ends up with, rear yard setbacks, side yard aggregates that don't meet, one side less half than the other. But that's standard for this area.
No height variance,
I
right?
was just gonna
That's
ask
correct. No height variance.
Okay.
Which we
how
might
does-
need if we needed to elevate the structure.
So your zoning table says building height allowed is 30 feet? And your
Yes.
code is 25.3, was that the average grade? Is that what that, because your elevations show it up as like 32 feet.
Normally it goes by the crown of the road.
Yes, so for an addition, it would go Crown Road to Ridge, the elevation, the heights that we show on A200 are relative to sea level. So
Gotcha.
What kind of access is there to the platform for the generator and the ACs for maintenance?
it would just be ladder access, which is somewhat of a standard way of doing it in this area because property size and so on, it doesn't really allow all the time for, say, a staircase or something like that.
And that's being installed above the DFE?
That is, yeah.
Okay, what is there, because of the addition, is there any additional HVAC or electrical that's got to be installed?
There, I believe there will be some sort of dedicated system to this area. We have,
The equipment being proposed would be above the design flood elevation.
that's correct.
Is it going to be like a sub panel that would be, well, it's only 2 feet, so that shouldn't be a problem.
Right,
2'4", right? Yeah.
correct.
Just going through my normal questions when we have a flood zone variance. Can you just talk about the numbers that were qualifying it or not qualifying it for a substantial renovation?
I don't have all the financial information in front of me.
Okay.
I
Do we
just,
have it?
Yeah, it's in the minute.
Okay, shame on me.
I know that the state required or requested it to be calculated in one specific way, and now the town of Hempstead had been developing their own way of equalizing how to analyze all the different structures, which I think we sort of got caught up in as they were developing it, which to come up with this fair way, which I believe they've achieved. But you know, the application was initially started in December of 2022.
When we're looking at the appraised value to determine substantial renovation, is that appraised value of the total property and building or just the building?
Just the building.
Just the building. Now, I think was there a number of 1.9
I'm
million?
gonna read what I have a valuation of 935,000.
930.
70, and then the construction cost estimate of approximately 350,710.
The
Does that sound right?
935 was just the building?
That's correct.
Wasn't clear to me from in looking at the appraisal numbers.
I think on page 3 or 6 on the right-hand side, they break it down. Let's pull it up.
I got 71 pages on the exhibit,
Yeah.
so.
I think this little one is. Opinion of site value. All the other stuff is.
Okay, so on page 3, on the right-hand side, it talks about the dwelling. Total estimated cost is 935,073.
Okay. Yeah.
Yeah, opinion of site value is 439, but is that locked in?
Right. No. And then underneath that, you'll see the dwelling at square footage and the garage at square footage. You take the 899,000, and add it to the 36,000. That's where you get the 350,073.
Thank you for that.
Mm-hmm. And I know we went out and got some proposals for the project that were also issued. And I think that, you know, putting those two numbers together, it was clear to the state that it wasn't a substantial renovation. And again, the town has their own computations. They use the FEMA software nowadays to figure out the value of the existing structure, and then they do a calculation on the proposed, and again, not substantial.
You don't have any more questions? Okay. Erica, Palin, you have any questions for the petitioner?
I'm good.
No,
Okay, we're gonna go talk this out and we'll be back as soon as we can.
Okay, great. Thank you so much.
Thank you.
All right, take care.
We're off the.
Here.
Okay. We're going back on the record. Everybody's present.
Ready?
Yes, we're ready. Thank you. With respect to petition number 2023-0496, Mr. Daniel Labrizzi, petitioner seeking relief from 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section AJ 801.2, and 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section R322.2.1. The board makes the following findings. 1, the subject dwelling is located in a flood hazard zone AE12. Number 2, the existing first floor elevation is 11.7 NAVD 88, and the base flood elevation, which is known as the BFE, is 12 NAVD 88, according to an elevation certificate submitted with this application. The required design flood elevation, which is the DFE, is 14 feet NAVD 88 upon addition of the New York State Freeboard. Number 3, petitioner wishes to make a two-story addition of approximately 644 square feet to the north of the dwelling. Number 4, this addition will include a mudroom, new kitchen, and den on the first floor and a master bedroom and master bathroom on the second floor. Other work proposed in this project includes removing an existing kitchen and constructing a front patio and an exterior mechanical platform. Number 5, the applicant has provided a contractor's cost estimate for the work at approximately $350,710. A valuation of $935,070 for the replacement cost of the existing dwelling has also been provided. This valuation was performed by a licensed appraiser. Number 6, these estimates suggest that the proposed additions, coupled with all other incidental construction taking place with this permit application, are not considered a substantial improvement. Number 7, compliance to R322 of the Residential Code of New York State would require elevating the first floor additions by approximately 2.3 feet above the current existing first floor elevation. This is impractical as the floor elevation should align. Number 8, the FEMA publication titled Substantial Improvement, Substantial Damage, Desk Reference would allow such additions to be made without the need to elevate the floor above the base flood elevation. Number 9, petitioner has stated that the addition will have a crawl space with a concrete slab that will be at the same level as the adjoining grade with code compliant flood vents installed. Number 10, the local code official has given support to the petition's request for a variance to uniform code flood requirements in this matter. Did I skip over? You're good. No, this is not my motion form. Hold on. Sorry, bear with me. I got to toggle back and forth now. Following findings with respect to 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section AJ 801.2, and 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section R322.2.1, the board finds strict compliance with the provisions to Uniform Fire Prevention and Building Code would entail practical difficulties or unnecessary hardship and would create an excessive and unreasonable economic burden. And the granting of this variance will not substantially adversely affect the Uniform Code's provisions for health, safety, and security. So wherefore it is determined that the application for the variance from the provisions of 19 NY CRR Part 1220, 2020 Residential Code of New York State, Section AJ 801.2, and 19 NY CRR Part 1220, the 2020 Residential Code of New York State, Section R322.2.1, be and is hereby proposed to be granted with the following conditions. So the addition by itself, nor coupled with any other incidental construction taking place with this permit application, shall not be a substantial improvement. That all materials for the addition and all new construction below the DFE elevation of 14 shall be flood resistant. number three, that any new electrical or mechanical equipment and devices shall be suitable for wet locations or be located above the DFE. And number four, that in all other respects, the applicable provisions of the uniform code shall be complied with, including but not limited to the code's provisions for flood vents in the underfloor space of the addition. And I'm having trouble toggling here.
You need to ask for a motion.
I do, but I just want to get the. So I need a motion to approve with these conditions.
Andy, so moved.
May I get a second? Mr. Pavone, second. All in favor?
Aye.
Right.
Palin, aye. Erica, aye. Motion is approved. Furthermore, it should be noted that the decision of this board is limited to the specific building and application before it as contained within the petition and should not be interpreted to give implied approval of any general plans or specification presented in support of this application. So we had those four conditions, Joe. Any questions?
No, thank you very much. I appreciate it.
Thank you. Good job today.
All right. Thank you so much.
Thank you.
Take care.
Bye-bye now.
Are we off the record, Chairperson?
We're going to jump to the next hearing.
Okay, but we're done with this one.
Yep, we'll stay on the record. Just want to make sure that 0568, we have Mr. Lester Katz. Mr. Katz, are you here today? Let's see him on the list.
So I saw the name on the screen.
Muted. He's muted. Mr. Katz, you're muted. If you could unmute. Good.
So is it lunchtime?
I'm the homeowner here, Mark Schmerler, and Lester is
Hi,
here
Mr.
today.
Shirella. How are you
I'm
today?
I'm just letting him know because that
Okay.
he's still muted. I'm texting him, letting him know.
Hello, somebody calling me?
Yes, Mr. Katz, your case is up. So we're
Oh,
gonna,
sorry about that.
no problem. We're gonna read some stuff into the record and then I'll give you the floor, okay?
Sure.
Now I gotta get my stuff in order. This is 568. Get my link here. Okay. All right. On the record. Third and final hearing today is in the matter of petition number 2023-0568. Petitioner is Mr. Lester Katz for Mark Schmerler. This petition pertains to an existing detached two-story, one-family dwelling of wood frame construction. The dwelling is approximately 4,560 square feet in total gross floor area and is located at 942 Carroll Avenue, Town of Hempstead, County of Nassau, State of New York. Petitioner is seeking relief from 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section AJ 801.2, which states that additions shall comply with the provisions of this code, except where required by this section. Unaltered portions of the existing building shall not be required to comply with this code. And 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section R322.2.1, which requires that buildings and structures in flood hazard areas, including flood hazard areas designated as coastal A zones, shall have the lowest floors elevated to or above the base flood elevation plus 2 feet, or the design flood elevation determined in accordance with sections R322.1.4 through R322.1.4.1, whichever is higher. Petitioner wishes to construct additions to the first floor that are structurally connected to the existing dwelling and are below the design flood elevation. Okay, Mr. Katz, you have the floor.
All right, good almost afternoon to everyone. Thank you for taking our case. So yes, as stated in the record, what we have here is a single family home in Woodmere. And the family that lives there, it's a large family with, thank God they have 8 children and an aging parent that also needs to stay with them. So as part of that, they're wanting to expand their living area, kitchen, and also provide a guest room with a handicapped accessible bathroom, all on the same level. So that obviously it would be very difficult for the parent who is disabled to be able to go up and down levels. So they want to keep everything on the same level. And again, with a large family like this, they want to be able to expand their living and dining area. Obviously, meal times get to be very large, and so they have a nice amount of space on the side of the house, and they're looking to expand this level. The level, as stated in the documentation, is 8.4 or 8.46 per the surveys and the elevation certificate, which is above the base flood elevation of 8 in this zone, below the obviously the design flood elevation of 10. So, and as stated, this level was not damaged during Superstorm Sandy. They have a lower level that has some mechanical in it. It was a garage at one point, but it's all mechanical areas, and that was the area that was repaired during Sandy. This is the family is the father is a rabbi who has long-term ties to the community and is planning to stay there for a while, so this will help him achieve that. And again, this is just a one-story extension piece going out to the side. They want to go out approximately 20 feet, and then the front and the back, 6 feet in the front, 5 feet in the back for extending the bedroom and handicap bathroom, and the back 5 feet for the kitchen to expand the kitchen. So that's basically it. Obviously, having steps going to those extensions would be not practical in middle of rooms and in middle of kitchens, things like that doesn't work for them. So we're asking relief from the code as cited. The approximate area of all these additions is about 1,000 square feet. There will be the foundations that will be put in will be consisting of helical piles because this isn't a flood zone, and we are not substantially improving the house by more than 50%. So therefore, we're asking to do this as of right, and that's basically our request. Thank you.
Clarification, is it slab on grade?
It'll be yes, with a small crawl space underneath. But essentially, it's a slab on grade.
So
Sorry, I apologize. I didn't hear that.
That's okay. We had multiple people talking at the same time. So the question was whether it was a slab on grade or not, and I think the answer was yes, but it's a little deceiving on the foundation plan.
If there's a crawl space, it's not a slab on grade.
Right.
Yeah.
No, it's to match basically where the first floor is now. And the first floor has a slight raise. They will be putting in a ramp in the front to be able to get to this level. So
Is the existing house on piles?
I believe so, yes. Well, yeah.
Yeah.
So, I'm sorry, can we go back to my original question? If it's not slab on grade because you're proposing flood vents, right? So there's a crawl space?
Yes.
So if you recall, I don't know if you were listening to the previous hearing, but there was a discussion about the slab level with the adjacent grade and the flood vents for code. So you're going to have that.
Yes.
You'll have that situation.
Yes, this is slightly raised by approximately 1 foot above grade is where the finished floor is. So I think if it's possible, we would put in flood vents. It may be a little too tight because some of the flood vents are 6 to 8 inches. So, but the plan is that if we are able to get the flood vents in, we would put them in.
The materials of construction.
Yeah, so the kitchen will be impervious, the tile surfaces, whatever normally not carpet. There's no carpet or anything like that planned in here. This would be pretty much tile. The bathroom is tile. The dining room and the living room would have a finish that we could put in something that's flood resistant finishes in there as well if that's necessary.
Well, aside from just the finishes, will the insulation and wallboard be flood
Yes.
resistant?
Yes.
That's not indicated on the
The
plans.
drawing shows spray foam insulation
Where?
on this section, and then it calls
Yeah.
for hardwood flooring.
Yes, we wouldn't be using any bat insulation. It would be,
No, it's in the,
Yeah, see, the first page didn't show it. Shows.
no, there's some wall sections and building sections, so over here in this wall section.
Okay.
So then there's no hardwood floors, there'll be like a tile, spray foam insulation.
yeah.
Okay, so that would probably be one of the conditions for the flood resistant,
Materials, yeah.
below the DFE. Can you just tell me the square footage of the new construction and the cost of that?
Yeah, it's approximately 1,000 square feet total. And we have a quote from the contractor for doing this for $125,000, being that.
Can I have his name, please?
uh,
That's pretty amazing. That's like
it was
$100.
in one of the documents we sent over.
Yeah, I don't have it.
Voltaire Solar LLC in Valley Street.
Okay. I mean, is that real? In today's economy, I mean, $100 a square foot? I mean, I've seen kitchens at $125,000.
Well, there isn't, this would just be expanding the existing kitchen, so it's not from scratch. The bathroom figure is it's gonna be very basic finishes, so 10 or 15,000 for the bathroom, and the living room, dining room is just a white box essentially. There's not, in terms of plumbing, there's not really a ton of plumbing work here, and then you have the roof. Again, it's a one-story structure, so.
When you're opening it up, so you gotta put probably some steel beams in there to support the second floor. I think you
There
showed.
may be one beam going in there by the kitchen.
Yeah.
But otherwise, and the room in the front is small, so we're gonna try to do it without any steel if possible. Or we could just use LVLs or something with flitch plates or things like that.
Is there gonna be an addition to the heating in here?
Yes, this house actually has a very unique heat pump system. It's like an air-cooled heat pump system that would be expanded.
Where's the equipment?
It's located in the lower level at this moment.
If that's gonna be expanded, is that gonna be located above the DFE?
Well, I think actually the homeowner might be able to speak to this since he's installed the system. He's the one who knows the most about the system, but I don't believe there's any additional equipment needed.
Yeah, if you want me to speak to it, it's an air to water heat pump, which basically has, the fuel source instead of being oil is electric. And basically all you have to do is extend the piping that's currently there. So it's basically taking the extra piping and putting it into the same loop that it is. So it's very minimal for baseboard heating. So there's actually no equipment when it was put in. It's already oversized. This was actually one of the first ones that went in all of Long Island. So this is, not really major addition. It's some fins and some piping around the.
Yeah, so to answer this question, there's no new equipment, you're expanding off the existing system that can accommodate.
Right, expanding already existing systems to lower the cost, to keep them as, as possible, low as possible. The key impetus here is, disabled mother-in-law who's widowed, who I've given Lester, if we needed them, letters from both multiple doctors. She basically can't live alone anymore. So that's why we're, doing all of this, so she could be with her family. It keeps her alive to be with grandchildren. And so we're the only people who have the room in the entire family to bring her in. So,
Okay.
So we're doing it as we said, as cost effective as possible. No fancy finishes, sheetrock, spray foam insulation. Sorry, somebody was trying to call me. And in addition to that, we're not doing anything really fancy here. You know, hi-hat lights, nothing really there. Buy 15 of them at Home Depot for, I don't know, $100. So nothing really crazy. And all the electric is capable of holding it right now.
The local CEO is okay with the application?
Yes.
Yes. Not opposed to granting?
I'm sorry. Somebody said yes, but I'm not sure who.
Coordinated.
Okay, thank you.
So we talked about flood resistant construction. Oh, I don't know if we got the value, what's the value, the replacement value of the dwelling? We have that number?
We do have the current market valuation that was done as an appraisal report. I'm trying to, let me just see where that number is. It's a 27-page report. Right, so that's on page 3. That's of, what is this? J, attachment J, and the house with the total cost of the whole dwelling. It looks like it's $900,000 in that rate, or $700,000 because of depreciation. So $750,000, I think, is the cost of improvements, and the value by cost approach is over $1 million. So again, that was included as part of our packet.
Okay.
Yeah, I mean, it's basically, this is a 4,000 to 5,000 square foot dwelling that's being expanded by 25%, 20% at most.
I just wanted to get those numbers on the record. Any other questions from the board members? Erica, Palin? No?
I'm good, thank you.
Okay. There's no other questions. We'll go deliberate and we'll be back with a decision.
Thank you so much.
Okay, thank you. All right, back on the record. Thank you. With respect to petition number 2023-0568, Mr. Mark Schmerler, the petitioner is seeking relief from 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section AJ 801.2, and 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section R 322.2.1. The board makes the following findings. Number 1, the subject dwelling is located in a flood hazard zone AE8. Number 2, the existing floor elevation is 8.46 feet NAVD 88, and the base flood elevation is 8 feet NAVD 88, according to an elevation certificate submitted with this application. The required design flood elevation is 10 feet NAVD 88 upon the addition of the New York State Freeboard. Number 3, the petitioner wishes to make a one-story addition of approximately 1,000 square feet to the west of the existing dwelling. 4, the addition will comprise of a living room, a dining room, a den, a mudroom and bathroom, and a kitchen extension. Number 5, the applicant has provided a contractor's cost estimate for the work of approximately $125,000 and an appraised market value of $746,100 was performed by a licensed appraiser. Number 6, these estimates suggest that the proposed additions, coupled with all other incidental construction taking place with this permit application, will not be a substantial improvement. Number 7, compliance with R 322 of the 2020 Residential Code of New York State would require elevating the first floor additions by approximately 1.5 feet above the current existing first floor elevation. This is impractical as the floor elevation should align. Number 8, the FEMA publication titled Substantial Improvement, Substantial Damage, Desk Reference would allow such additions to be made without the need for elevation of the floor above the base flood elevation. Number 9, the local code official has given support to the petition's request for a variance to uniform code flood requirements in this matter. With respect to 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section AJ 801.2, and 19 NYCRR Part 1220, the 2020 Residential Code of New York State, Section R 322.2.1, the board finds strict compliance with the provisions to Uniform Fire Prevention and Building Code would entail practical difficulties or unnecessary hardship and would create an excessive and unreasonable economic burden. And the granting of this variance will not substantially adversely affect the Uniform Code's provisions for health, safety, and security. So wherefore it is determined that the application for variance from the provisions of 19 NYCRR, Part 1220, the 2020 Residential Code of New York State, Section AJ 8 of 1.2, and 19 NYCRR, Part 1220, the 2020 Residential Code of New York State, Section R 322.2.1, be is and hereby proposed to be granted with the following conditions. Condition number 1, that the addition by itself or coupled with any other incidental construction taking place with this permit application shall not be a substantial improvement. Number 2, that all materials for the addition and all new construction below the design flood elevation of 10 feet shall be flood resistant. Number 3, that any new electrical and mechanical equipment and devices shall be located above the design flood elevation or suitable for wet locations. Number 4, that in all other respects, the applicable provisions of the current uniform code shall be complied with, including but not limited to the code's provisions for flood vents in the underfloor space of the addition. I need a motion to approve with these conditions.
Andy, so moved.
Can I get a second?
I'll second it.
Mr. Pavone, second. All in favor?
Aye.
Aye.
Well, aye. Motion is approved. Furthermore, it should be noted that the decision of this board is limited to the specific building and application before it as contained within the petition and should not be interpreted to give implied approval of any general plans or specifications presented in support of this application. So approved with those conditions. You have any questions?
No, it's very clear. Thank you very much for your time and your consideration, and we appreciate it and have a wonderful day.
You too. Thank you. Good luck with your project.
Thank you very much.
Thank you.
Bye.
Okay, we're off the record.
We're off the record.